think, yeah, we are live, and so we should be ready to go as soon as we get the cue from my team. Does that work for you? Excellent. Councilmember Pinto, good to see you.
Good morning.
All right, council members, we are now live on YouTube. Councilmember White, you may begin when you're ready.
Thank you. Good morning. I'm Robert White, council member at large and chair of the Committee on Government Operations and Facilities. Today is Thursday, September 22nd, 2022. The time is now 10:14 a.m. and I'm calling to order this joint public hearing of the Committee on Government Operations and Facilities and the Committee on Judiciary and Public Safety. Notice of this hearing was published in the DC Register and on the council website on June 17th, 2021. There's one bill on the agenda today, B24-446, the Attorney General Civil Rights Enforcement Clarification Amendment Act of 2021. This legislation was introduced by Chairman Mendelson at the recommendation of the Office of the Attorney General for the District of Columbia. A narrower version of this legislation is currently in effect in emergency and temporary form through November 19th, 2022. The legislation we are hearing today would in part make those provisions permanent. B24-446 amends the Human Rights Act of 1977 and expressly grants the Attorney General the right to obtain injunctive relief and civil penalties for violations of the Human Rights Act. This bill also grants the Attorney General a full range of investigative tools to uncover and penalize discrimination in the district. Finally, it clarifies the application of the Human Rights Act to all real estate and property management professionals. The Human Rights Act of 1977, effective December 13th, 1977, was enacted to protect people from discrimination. The Attorney General has assisted in carrying out the purpose of the Human Rights Act by investigating and bringing civil actions to address civil rights violations. In the course of the Attorney General's investigations, defendants have challenged the Attorney General's authority to bring civil actions in the public interest. Similarly, defendants have challenged the Attorney General's authority to obtain injunctive relief and civil penalties. The Council, in response to the coronavirus emergency, expressly confirmed and authorized the authority of the Attorney General in enforcing the Human Rights Act alongside the Office of Human Rights, or OHR. That authority has now been confirmed for most of the last 2 years. OAG argues that the authority provided in this bill supplements the work of the Office of Human Rights by adding resources to investigate civil rights violations in order to protect victims of discrimination. In addition, the Attorney General has requested clarification on the applicability of the Human Rights Act to real estate organizations and property managers to better address housing discrimination. We know of the Attorney General's work in addressing housing conditions and access issues across the district, and we'll be digging into how this clarification will help later in this hearing. We also will hear from the Office of Human Rights, or OHR. OHR is the primary executive agency responsible for defending human rights in the district and enforcing the Human Rights Act. I understand that OHR will raise their concern that the authority the Council granted to the Attorney General, which this bill would make permanent, is too broad and might result in issues with coordination and case finality. OHR has also raised concerns around elements of this bill that could impact the enforceability of Commission on Human Rights decisions. While I believe the Attorney General has and must continue to play an important role in bringing civil rights cases in the public interest to protect the rights of our residents, I take OHR's concerns seriously and look forward to a continued discussion of those concerns with the office. I will now turn to my hearing co-chair, Councilmember Allen, and colleagues for any opening statements they have.
Thanks so much, Councilmember White, and good morning to you. And thank you for scheduling today's joint hearing with the committees. Although the council has already clarified the Attorney General's authority with respect to the Human Rights Act, in some respects through emergency and temporary legislation, I do think it's important that we do so permanently, one way or the other, and in a manner that is in the best interests of district residents and makes sense, given the Office of Human Rights' current processes. The district has had to navigate this issue of dual authority with our still relatively new independent Attorney General's office, and it's critical both to empower OAG to balance its role with respect to other district enforcement agencies as we do with other statutes. I think today's hearing is going to help tease out what that best relationship should look like with respect to anti-discrimination protections. And at the end of the day, let's all be very clear, everyone wants both the best outcome for residents and a fair process. So my questions today will be in that vein as we work together to figure this out and then be able to ultimately move permanent legislation forward. So I appreciate it again, Councilmember White. Happy to be here in this joint hearing with you and appreciate your work on this and your staff. And so I'll kick it back over to you, and I appreciate that we're joined by Councilor Pinto as well.
Thank you, Chairperson Al. And Councilmember Pinto, do you have an opening statement?
Yes, thank you so much, Chairman White and Chairman Allen, for holding this really important hearing today. The Human Rights Act is a really critical tool that the district has to protect all who live, work, and visit our city from discrimination in housing, employment, public accommodations, and our educational institutions. Too many individuals continue to face discrimination on the basis of race, sex, gender identity, sexual orientation, disability, family responsibilities, source of income, and other protected traits. Such discrimination undermines the dignity of these individuals, the cohesion of our communities, and the integrity of our society. This bill will expand the available enforcement mechanisms to ensure that violations are appropriately addressed. It will also close gaps in the existing law to ensure that we are rooting out discrimination where it is occurring. I'm looking forward today to hearing from the Office of the Attorney General and the Office of Human Rights about how they anticipate working in tandem to most effectively provide district residents with robust protections from discriminatory practices and to enforce violations of these rights. So thank you again, Chairman White and Chairman Allen, as well as to your teams and all of the public witnesses who are here to testify today.
Thank you so much. Let us move into our public witnesses, and our non-government witness panel will include Matthew Kronzek, Liz DeBarrios, and Commissioner Robert Vincent Branham. As you all get queued up, let me sort of give the rules of the road. Everybody should have received a copy of the witness list yesterday. I'm going to call witnesses in the order that they appear on that list. When I do, the staff will promote you to a witness, so you will drop out of the hearing momentarily, but you'll come back in as a panelist at that time. You can unmute yourself and turn on your camera. Public witnesses have 4 minutes to testify. Advisory neighborhood commissioners have 5 minutes to testify. Matthew Kronzek, we promoted you to a witness. It may require you to accept on your end. If you have accepted, then I'll ask that you turn on your camera, and then we will know you're here. Liz DeBarros, are you with us?
I am.
All right. Why don't we begin with you? Welcome.
Good. Good morning. Good morning, Chair White, Chair Allen, members of the Committee of Government Operation and Facilities, and the Committee on the Judiciary and Public Safety, and also Councilmember Pinto and staff. My name is Liz DeBarros. I'm the CEO of DCBIA. I'm also a resident of Ward 7. As you're well aware, DCBIA is the leading voice of real estate development in the District of Columbia. I thank you for the opportunity to testify on Bill 240446. DCBI members are engaged in every aspect of real estate development and operations in the district, and our members are directly affected by this act and its context. We recognize the value and importance of ensuring that district residents are protected against discriminatory practices and violations of the DC Human Rights Act. We also understand that given the OAG, the ability to successfully pursue and prosecute bad actors or violators of the District of Columbia Human Rights Act is important to further that goal. We appreciate that this act seeks to address those concerns directly, and we'd be happy to work with both of your committees to ensure that these goals are achieved. As introduced, Bill 240446 provides the OAG with investigative and enforcement tools, and among other things, clarify the application of the Human Rights Acts to all real estate and property management professionals. While we understand the importance of prosecuting violators in the DC Human Rights Act, the act as written is essentially seeking to see if anyone within the real estate profession is discriminating against the DC Human Rights Act and its 21 protected classes without any solid indication of discrimination. It lacks a targeted approach. The act, as introduced, does not seek to find out who the bad actors are on an individual or case-by-case basis. Instead, the act as introduced assumes that everyone is a bad actor and works from that basis. This can again be seen in the following language from the act. If the Attorney General has reason to believe that any person is violating the provisions of the act, the Attorney General may bring civil action in the name of the district, and civil penalties can be sought. This gives significant power to the AG to bring civil action against anyone if the AG has reason to believe that the person is violating the act and can conduct large-scale investigations. This is too large and too general of a scope. The act also allows the AG to investigate a person through many means, including subpoena witnesses, administering oaths, collecting integratories, and compel production of documents for any reason to determine, whether or not he or she wants to move forward with seeking relief. We urge the committee to not grant this broad investigative authority, especially in the absence of demonstrated compelling need for an investigation into the person. If the language remains, it leaves an unnecessary broad power that can have serious, immediate, unintended consequences for economic development projects, and the DC economy relies on brokers, salespersons, project managers to keep industry moving and paying real estate taxes, deed and recordation taxes, sales taxes, income taxes, licensing, permit fees, just to name a few streams. This legislation may have the unintended consequence of making those identified persons unwilling to work with the industry if they can be subject to investigations without any formal charges. These concerns well outweigh the benefit, if any, the district might gain from this overly broad investigative tool given to the AG and its office. Once again, it's clear it is the OAG has the authority under the Human Rights Act to investigate any discrimination as a violation of the 21 protected traits. We ask that the bill be narrowly tailored to ensure we properly go after bad actors and not treating all people in the development industry as bad actors. To close, DCBI would welcome the opportunity to work closely with both committees to ensure that these changes to the bill can occur. We are encouraged by the city's desire to enact legislation aimed at further protecting human rights of the residents of the city, while also maintaining a robust real estate economy. We look forward to continuing to work with you to ensure that balance. Thank you for the opportunity to testify.
Thank you so much, Commissioner Robert Vincent Branham. Welcome. Commissioner Branham, can you hear me?
Yes.
Excellent. Welcome.
Okay, so I'm up next.
You are.
Okay, thank you. I welcome the opportunity to offer my testimony, and I realize that it's not necessary or required, but I want to say that I present my testimony under oath, And if anyone has a issue with something that I'm about to say, they're free to come before the council and respond under oath. The Home Rule Act states that each A&C commission may advise the council, the mayor, and each executive agency and all independent agencies, boards, and commissions of the district government with respect to all proposed matters of government policy. Accordingly, racism and discrimination within the district government are ripe subject matters for comment by commissions. The act prohibits commissions, but does not prohibit commissioners as citizens from initiating legal action. Each commission may initiate its own proposal for district government action. Human rights and racial equity require constant vigilance by all people of goodwill and strong character. I commend DC Attorney General Carl Racine for introducing this legislation. Government offices and agencies are managed by people the public has entrusted to be fair, just, and non-discriminatory. People who discriminate are fundamentally cowards and liars. They seek and relish in the emotional and psychological discomfort of others. They are bullies. Discrimination works to rob people of their dignity. It is a scripted effort to dehumanize and destroy dreams and aspirations. To fight discrimination, you must believe all discrimination is evil, wrong, and a lie. Attorney General Racine, by this legislation, demonstrates he is a believer in and dedicated to fighting discrimination and injustice. This legislation gives the Human Rights Act greater leverage to seek timely and substantive settlements responding to discrimination. Rather than rendering OHR administrative or court decision meaningless, this legislation strengthens them both. The involvement of the DC Attorney General through this legislation is not intrusive, but nor is it tensions. Moreover, simultaneous and separate government agency investigations are not uncommon. The legislation's provisions of a memorandum of understanding between OAG and OHR is thoughtful and accommodates the interests of both. It protects the claimants and the people of the District of Columbia. There may be some who are opposed to the OAG's proposals, uncomfortable with my tone and reflection. However, they cannot assert that Attorney General Racine's anti-discrimination efforts and my support for this legislation are based on a lie. The systems and structures of discrimination must be eradicated because they are unfair and unjust. Individuals, regardless of title or position, should not find comfort or cover to discriminate and to lie. As part of any district civil rights overview and their official duties, commissioners should not incur discrimination because of their advocacy. Those who discriminate would not be so strong if they did not have silent accomplices in the workplace. Advocates against discrimination must be authentic. Just as other elected officials, like the council members and the attorney general, commissioners deserve respect and should be given great weight. Finally, I close my testimony on a personal note. This will be one of my last appearances before the council as an elected official. However, I will remain a commissioner until my term ends in January 2023. By the grace of God, I will continue to speak out and serve my community and the people of the district. I am thankful for the courtesies extended to me by the council during all my previous testimonies on issues important to district residents and on behalf of mayoral nominees for positions requiring council confirmation. When asked, I did not hesitate to express my support. I also thank the residents of ANC 5E08 for their votes, support, and trust. I will forever be humbled by the steadfast support of my family. In my collective community service, I have been blessed to have partnered with persons of principle. Sadly, I've also been disheartened and disappointed by people seeking only glory for themselves, showing disdain for truth and disregard for the value of a fair shot. Throughout my service to the people of the district, whether elected or by appointment, I was honest, faithful, and loyal. If there is a message I will leave with those within the hearing of my testimony, it is to be true to yourself, to others, and to God. Many often speak of DC values. However, as a proud military veteran, I do want to share 3 core values of my United States Air Force: integrity first, service before self, and excellence in all we do. These core values should be taught to our children and be a covenant to one another. Let me repeat, those who lie and discriminate are dishonest cowards, as are those who are silent. Finally, the Lord said to Elijah, I have remaining to me in Israel 7,000, all whose knees have not bowed unto Baal, and all whose mouths have not kissed him. Though they share the same burdens, there are many people of the district who have not bowed, kissed, and given in to the spirit of lies, discrimination, racism, bigotry, and white supremacy. I welcome this opportunity, and I strongly support the Attorney General's Civil Rights Enforcement Clarification Amendment Act, and I thank you for your time.
Thank you so much, Commissioner. Let me also thank you for your service to the District of Columbia. You're saying under oath that you're not running for ANC again?
I'm saying under oath I'm not running.
Uh-oh. Uh-oh. Well,
let me say this. Let me be more specific. I'm not running for ANC Commissioner in 5E08 or 5E05 under the new redistricting. Okay.
I'm going to leave the follow-ups for Tom Sherwood. I think if you want a Kojo show, he'd have a few for you. But I appreciate your testimony. Really appreciate the testimony of Liz DeBarros. Liz, are you still with us? I hope so. I have a few.
I am. Yes.
Excellent. Excellent.
Mm-hmm.
Your concern, part of your concern was the breadth of OAG's power, that this, I quote, if the Attorney General has reason to believe standard is too broad. What would be, in your opinion, a better standard?
I think what I'd like to do, if we can do this, is get some members to maybe speak to your committees to give some specific language about it. It's just as it's written, it's just too broad. And it sort of treats the entire industry as bad actors rather than, so we can give you specific language.
Okay, as you all are considering that, one question I would ask you to consider is, if discrimination is happening and people don't know their rights, what should happen in that circumstance? My concern here is a combination: one, people who don't know their rights, but also people who don't believe in the system. These are the people most likely to be discriminated against. And so if we're saying, well, the Attorney General only has authority to take action if these people seek out the Attorney General's help, I'd have concern with that because I know that that's just not how, unfortunately, a lot of people who are downtrodden operate. And so there may be some language that takes both of these, your concern and my concern, into account. One other question for you. There was a part that sort of later in your testimony where you were talking about people who might be unwilling to work or do business in the district, and I wanted to better understand that point.
Yeah, I think it's, just at the legislation itself, I'll just say again, it's sort of, as it's overly broad, people could have some hesitation with that, given that it's too broad and it doesn't narrowly focus too specifically to going after bad actors. We're obviously not saying anything about protecting bad actors. The city has all its rights, and it should continue to go after bad actors, and bad actors need to be targeted. But I think, we want to be involved in this process before this legislation becomes permanent, to make sure that we address that and it gets to the right folks who are violating the law.
Okay. And do you have a conclusion on whether the Office of the Attorney General should have investigative powers here?
I don't have that. I probably can find someone on our team to tell you to answer that question off the top. I don't know. Okay.
Commissioner Branham, do you have thoughts on how we ensure protection for people who may not know their rights, or who may not believe it's worth their time to pursue it?
I have thoughts, and I believe that there has to be a constant evidence that the government really is committed to rooting out discrimination. We all are aware of circumstances where government agencies have a reputation for discriminating. And I'm not talking about just the public sector. I mean, with individuals of the public, and how the services and the like. I'm also talking about employees. The Attorney General should also be looking at discrimination of district agencies against employees. When there's evidence, clear evidence, and documented, there should not be protection for agencies in this atmosphere. And if the government wants a reputation of fighting and rooting out discrimination in its services to the public, it has to clean its own house. It has to clean its own house. And people have to stand and say, where are you? Why are you here? Why are you proposing to go after, quote, bad actors in public housing, in education, in retail? But for some reason, you are silent to those same bad actors in your own neighborhood, which is the government. The Office of Human Rights and the Attorney General need to put as much emphasis in rooting out discrimination within the government as it is trying to assure residents that it is protecting them from discrimination within the private sector in their accommodations, in homes, education, and the like. The two are inseparable.
I appreciate that. Doesn't speak to all of the issues of discrimination. I did introduce relatively recently the Elimination of Discrimination Against Women Act, which is pointing not to the private sector, but to government to identify and root out discrimination against women. But I do hear you that there's a broader issue. So I will follow up with you about that. Let me move to my co-chair, council member or chairperson Allen.
Thanks, Chairman White, and thanks to both witnesses here. You cover a lot of ground that I was going to do through your questions, so thank you. What I might do, I guess, Mr. Barros, just kind of a quick follow-up for you. Help me make sure I'm understanding and hearing your testimony correctly. So we have currently in effect, we have a more narrow authority to the AG, and this legislation would broaden that a bit. Is your testimony that you don't support the broadening, but you do support the more narrow authority that they have currently? As in, have you seen any negative impacts or the things that you've cited as concerns with the authority that they have right now? Or is your concern focused more on the permanent legislation would create a broader authority, and that's where your concern is?
Yeah, the concern is on the broader authority and as part of permanent legislation. So yeah, the idea that we do want to root out, discrimination for sure. But the Office of Human Rights and the OAG has some authority. So we want to make sure that it doesn't go so broad that, people who are not discriminating are caught up in long investigations and things of that nature. So we want to make sure that it targets, it's more narrowly focused.
Okay. Thank you for clarifying that. There was something in your testimony, though, that kind of I'm still trying to wrestle with a little bit. And the way, and forgive me if I didn't say this correctly, but the way that I heard it, and you were saying that the overly broad, and I think it touches on what you just said, you think it's overly broad and that it means that all housing providers, by having the HRA cover housing discrimination, it almost made it sound like you were saying that it's treating it as if all housing providers discriminate. Did I hear that correct?
Well, yes, it's that since the bill is so broad, it doesn't go after narrowly people who are violating. There are certainly bad actors in every industry and every part of the city. I'm sure that there are bad actors, and we want to make sure that the laws that are passed target those bad actors and not have unintended consequences for people who are good actors that get caught up in some overly broad language in the law. And I think that, our suggestion here is to just continue to work with both your committees to get that right balance. And I think we can do it.
Okay. I guess the way that I'm looking at this, just because the HRA covers housing discrimination, that's not saying that all housing providers discriminate. There is discrimination. And so we need to have the authority to be able to go at that, investigate it fully, and be able to take action and hold accountable. But I think just because the HRA says it's covering all housing discrimination as an example, I don't think that inherently means all housing providers therefore discriminate. I think it's just trying to set what is the protection that we want across the board. And then really the trick is, what is the authority that we want to be able to then take action when we find a violation? Not that every single housing provider out there in the world is bad, but that we're trying to make sure the authority exists to be able to investigate and take action.
Right, and we want to make sure that the authority to take action on a bad actor and not other good actors. It's not to, of course, to certainly ask questions if necessary, but to make sure that the law is going after people who are violating.
Then from a process standpoint, how would you establish what that threshold is? If you want to narrowly limit the authority for the AG to be able to do an investigation, how would you set a threshold to say, if they're doing an investigation because someone lodges a complaint, to then say, all right, well, that's a real complaint versus, well, that's not a real complaint?
I think that there could be some language that's added to this that could help address that. Now, it's legal, language that I don't have But I'm sure that there's a way to do it. And I think that with the time that we have before we get to a final piece of legislation, that we could do that. I think it's about the language in the law that could be addressed here.
Okay. I appreciate that. I know, I mean, for me, I certainly want a fair process. So from a pure process standpoint, I want to make sure there's a fair process. But I don't start from the assumption that by creating a protection against housing discrimination and giving authority, that's inherently bad. But I certainly am willing to hear kind of recommendations or review suggested language to see to better understand kind of what you think a solution could be to what you're describing as your concerns. But obviously, I want to make sure that the authority is there for our various entities to be able to take action and not create unnecessary hurdles or barriers when discrimination takes place, that there's a remedy and there's accountability for that. But I appreciate you walking me through that so I can kind of try to better understand where your concerns are coming from. And Commissioner, thank you for your testimony, Commissioner. I'll leave it to Councilmember White and the Kojo Show follow-up questions. But I appreciate that. So thanks for your testimony. Thanks, Mr. Chairman. I'll turn it back to you.
Thank you, Chairperson Allen. Councilmember Pinto, do you have questions?
Yes, thank you so much. And thank you, Commissioner Branham, for your testimony and for all of your service. It's been great to have you testify at many hearings over the years. Ms. Taveros, I want to follow up similarly to my colleague about your comments on kind of assuming culpability is also how I heard it. Can you elaborate on how the authority of application of the Human Rights Act to property managers will assume that type of culpability?
Well, I think it's just like I said in the testimony, if the Attorney General has reason to believe that any person is violating the provisions of the Act, the AG may bring civil action in the name of the district, and penalties can be sought. So it's significant power to bring civil action against anyone, and they can in a large scale investigation can be done. And then it is our sort of understanding and our belief that, like, if the legislation could be targeted to specifically for bad actors, people who have questions by the AG's office, doesn't answer questions properly, not responding, those kinds of things that they know that and create a history of problems, then the law should go after that person or that entity that's violating. I think that what we want to do is to add some language into the legislation that helps to address that.
But if the goal is to go after the person who is violating the law, then this language provides that tool to do so. So if that was removed, how would they pursue a case against an individual who discriminated?
Well, this is on top of something with something that that's already in with the Office of Human Rights. So it's an additional layer on top of what OHR is already doing. So I think making sure that the language is clear and narrow at this level with the OAG as well is important to just to make sure that we go after and prosecute bad actors.
Okay. And you talked a little bit about unanticipated consequences that could happen if this moves forward. Can you articulate what you're referring to and how that would play out in practice for property managers?
I think it's that if there is a a large scale sort of investigation that may not be for someone who's, necessarily a bad actor. There's a lot of process and delay that would take place for that entity.
Okay, so the concern there is if somebody was wrongfully alleged.
Right.
And that would just be a kind of strain on their time, their reputation.
All of that.
Okay. Isn't that the case for anyone wrongfully alleged now with Office of Human Rights Authority, or really any violation of the law that we have in the District of Columbia?
Yeah, that is true. And this adds another layer on top of OHR. So again, we just think that narrowing the focus to a bit to make sure that it's about people who are violating could really help here. And I think this is a opportunity to strike that balance.
Gotcha. Okay. Well, thank you very much.
Thank you.
For your help there and for your testimony today. Thank you.
Thank you.
Chair people White and Allen.
Thank you, Councilmember Pinto. I want to thank both witnesses from this panel. We will move to our—
Mr. Chairman, before we go, I just want to be clear, and that as we move forward, that we don't lose focus that the purpose of the Office of Human Rights and the Office of the Attorney General should be joined to eradicate and get rid of discrimination in all forms, in all places, in all spaces. And it should not matter what your position is or where you are. You do not have the freedom to discriminate against individuals regardless of their race, gender, political affiliation, religion, or any factor. It has to be rooted out, and we simply can't focus on housing, health, education. It has to be all factors, and we cannot let go that the conversation it should be limited to persons outside only in the private sector. We have to root it out in the public sector, in public employment. That has to become a part of this conversation and should not be overlooked.
I do hear you loud and clear. I appreciate it, Commissioner. Moving along, because we have another hearing right on the tail of this, and so we got to make sure we get through our government witnesses. But I do want to thank you both for your testimonies, and I want to welcome our government witnesses, Vikram Swarb, Chief Deputy Attorney General in the Office of the Attorney General, and then Kine, Interim Director of the Office of Human Rights. Welcome, Chief Deputy and Director. We will start with Chief Deputy Swarb. You can begin your testimony when you're ready.
Great. Do I need to be sworn in, or do I just get started?
Thank you. You do have to be sworn in, as you know, is the practice of this committee to swear in our government witnesses. So I would ask that you, both of our government witnesses, and do either of you plan on having team members who may answer questions for you? All
Yes.
Right.
Glendon, who's on the screen, may also answer some questions.
Excellent. And for you, Director?
Yes, Chair. I have Andrea Goppelwood here, our General Counsel.
Wonderful. All right, then I will swear all of you in at the same time. I ask that you raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you are about to provide to the Committee on Government Operations and Facilities and to the Committee on Judiciary and Public Safety is the truth, the whole truth, and nothing but the truth?
Yes.
I
Thank
do.
you. Thank you. Chief Deputy, did I miss anything else?
I think we're good.
Thank you. You can begin. Welcome.
All right. Good morning, Councilmember White, Councilmember Allen, Councilmember Pinto, and staff. My name is Vikram Swarup, and I have the privilege of serving as the Chief Deputy Attorney General here at the Office of Attorney General for the District of Columbia. I started my tenure in the office by helping establish our Civil Rights Section, which in the last 3.5 years has done some incredible work that I look forward to testifying about today. I'm pleased to be joined by OAG's Civil Rights Section Chief, Alicia Lendon. I'm before you in support of B24-446, the Attorney General Civil Rights Enforcement Clarification Act of 2021. This legislation will help ensure the Office of Attorney General can effectively pursue its mission of protecting the public interest and ending discrimination in the district by codifying 3 critical things in the Human Rights Act. First, express permanent authority for us to bring suit where there's a violation of the law. 2, the investigative tools we need to ensure that we are efficiently looking into potential acts of discrimination. And 3, the appropriate penalty structure for our cases where there is a violation of the law. In 1977, the Council enacted the HRA to secure an end in the District of Columbia to discrimination for any reason other than that of individual merit, and to ensure equal opportunity for all residents. In 2019, the Council recognized the benefit of additional investigations and complex civil rights litigation to fully realize the promise of the HRA, and thus funded a new civil rights section within OAG as a complement to the work of the Office of Human Rights and private advocates. That section has, in the years since, grown to 9 employees. The lawyers and other professionals on this team have secured many important wins for district residents, particularly in the area of fair housing. For example, we have litigated and won cases against large housing providers and realtors who discriminate against low-income housing voucher holders. In fact, we achieved the district's largest housing discrimination settlement to date, $900,000 in penalties in a case against Curtis Investment Group for discriminatory housing practices. In 2020, we filed 9 housing discrimination cases against 16 real estate companies and professionals, all for posting ads that discriminated against housing voucher holders. Through those cases, we secured almost $500,000 in penalties and fees for the district. But more importantly, these defendants must now comply with the law, maintain anti-discrimination policies, provide fair housing training to all employees, and report on future discrimination complaints to OAG. We have also worked collaboratively with the technology platforms like Zillow and Apartments.com to reduce discriminatory advertising on those websites. By publicizing these cases and other efforts, we have sent a strong message to the district's housing providers that discrimination will not be tolerated. This is translating into real behavior change. Since we began our fair housing work, a local advocacy organization reported seeing a steep decline in discriminatory ads for district properties. While source of income discrimination has been an important priority, our recent efforts stretch much farther. Earlier this week, we announced a settlement with a local developer and its owner for violating the HRA's prohibition on what's called blockbusting. Blockbusting is a practice where real estate speculators attempt to lower the value of a desired property by stoking the prejudice of other would-be purchasers by representing that minority groups are moving into a neighborhood. Blockbusting is an old school civil rights era form of discrimination that is rarely seen today, so this was a unique case. Polygon Holdings owned one half of a duplex, but wanted to acquire the other half to convert the entire property into condominiums. When the adjacent homeowner declined initial offers from the developer who wanted to make that purchase, a sign was erected on the property that stated Section 8 and student accommodation coming soon, in an attempt to reduce the desirability and value of the property that the developer wanted to purchase. While the homeowner later, with representation, sold the property to Polygon at a fair market value, her private resolution of the real estate transaction did not and could not remedy the harm that blockbusting tactics have on the district at large, casting protected groups as undesirable neighbors. With the temporary authority that we now seek to make permanent, we were able to obtain $300,000 in penalties and costs and injunctive relief against this developer. This is just one example of how even a single instance of discrimination, one sign, may merit OAG investigation and involvement, and what we can do to make sure it does not happen again. We've also worked to ensure that residents with disabilities receive the housing accommodations they need. Earlier this year, we filed a lawsuit against the DC Housing Authority after our investigation identified a years-long pattern of delaying implementation of disability accommodations, in some cases for so long that tenants died while waiting for an accessible apartment. This was after residents and advocates complained to us about years of frustration in trying to get these basic accommodations despite their best efforts to work with DCHA. OAG also recently won a motion against a property management company and building owner that refused for years to provide a designated parking space to a tenant with mobility limitations. We ultimately obtained a settlement securing the needed accommodation and more than $250,000, including payment to the tenant for her suffering. We are also currently investigating more than a dozen targets for potential civil rights violations using our temporary pre-suit investigative powers. These investigations are ongoing, and the legislation before you today would ensure that we are able to continue protecting the public interest by completing these investigations and filing suit if necessary. While I could describe many more of our civil rights successes, and I do want to mention our work on place of residence discrimination against our neighbors who live east of the river, I do want to turn to what the bill before you does. First, the bill expressly codifies OAG's authority to enforce the HRA through civil litigation. Second, it makes permanent the investigative and enforcement tools that were temporarily granted to us during the pandemic and which are vital to rooting out discrimination and to almost all of the efforts I've just described. Third, the bill also makes a handful of minor technical updates and strengthens the law based on lessons we have learned from enforcing it over the last 3 years, which is something that we do with all of the laws that we enforce, bring before you changes that we think could make the law stronger and protect district residents further. First, the legislation would add a section to the HRA clarifying that OAG can investigate and bring suit for violations of that law. Because the HRA does not yet include this explicit authority on a permanent basis, OAG has been enforcing the HRA through a combination of our common law authority, the temporary civil rights legislation enacted by the council at the beginning of the pandemic and then extended, and our consumer protection authority. OAG's common law powers to enforce district statutes were recognized by the District of Columbia Court of Appeals in 2017. However, without this express provision that we are proposing today, we must often spend significant time and resources in fighting efforts by defendants to challenge our authority. This is time and money better spent on combating discrimination. Express statutory authority will provide clarity and allow OAG to more efficiently use our resources to protect district residents. This bill would also place our civil rights work on equal footing with our other affirmative litigation efforts around consumer protection, workers' rights, tenant protection, elder justice, and other similar affirmative work with clear authority and dedicated resources. Second, the legislation permanently authorizes investigative and enforcement provisions necessary to effectuate the HRA's anti-discrimination goals. OAG relies on investigative tools and our ability to recover civil penalties to build strong cases and reach meaningful resolution in public interest matters. The many discrimination cases we have successfully resolved, as well as OAG's long track record of enforcing other statutes that provide these same powers, demonstrates that pre-suit investigative tools and clear penalty structures are practicable, effective, and critical to our work. The most powerful tool at issue here is our ability to issue and enforce pre-suit subpoenas. Without pre-suit subpoenas, OAG must first file a lawsuit and then seek documents and information through the discovery process. But when we can issue pre-suit subpoenas, we're able to conduct faster, more efficient investigations and pursue pre-suit settlements, such as the one I mentioned against Polygon Holdings. These settlements swiftly end unlawful discrimination and avoid lengthy litigation, preserving district resources. Additionally, when investigations result in a determination that the target did not violate the HRA, pre-suit investigations allow us to close the case without subjecting district businesses to unnecessary litigation. Also critical to OAG's work is our ability to see penalties against those who violate the district's anti-discrimination laws. The penalties provision in this bill mirrors the penalty structure that the council put in place for OHR matters, which was incorporated into OAG's temporary authority that we're currently operating under. Penalties like these provide significant deterrent impact and will allow the district to bring in resources to continue this important work. Lastly, in the legislation as introduced, we propose striking a provision of the HRA related to the administrative complaint process before OHR, which is the primary district agency tasked with protecting district residents from discrimination. Upon further consideration, we recommend removing that provision from the legislation as we move through this process. OHR plays a critical role in our civil rights enforcement by providing residents with accessible and decisive relief when they have experienced unlawful discrimination. OHR's administrative process allows complainants to avoid the time and cost of litigating in superior court while still achieving relief when their rights have been violated. OAG's role, on the other hand, is slightly different. We are tasked with enforcing the HRA to protect the district's interests, not necessarily the interests of an individual complainant. Both of these roles are critically important, and we see the efforts of our two agencies as complementary to one another. Indeed, the bill has a provision that contemplates a memorandum of understanding between our two agencies to ensure that we're working collaboratively and supporting each other's efforts. Given the different roles of the two agencies, OAG has concerns with the procedural provision that exists in the current law that blurs these distinct roles and can interfere with complainants' ability to obtain relief. Currently, the HRA allows either party in a housing discrimination case to remove the case from the OHR process to the Superior Court after there's a probable cause finding. When this happens, OAG becomes the plaintiff instead of the person who experienced discrimination, which creates real problems for both the complainant and OAG. This process is often detrimental to a complainant's case. It is most often triggered by defendants and has the effect of restarting the case and slowing down resolution. This provision also creates serious issues where the district's interests, which OAG is ethically obligated to represent, diverge from the complainant's interests. In the year since OAG introduced this legislation, however, we have heard from stakeholders and understand that OHR and some advocates have concerns about striking this provision. We appreciate these concerns, but still believe that reform is necessary and that there are solutions that could satisfy all parties. We'll coordinate with the council, OHR, and advocates to find a workable solution. But in the meantime, however, we recommend removing that part of the bill that strikes this provision in order to focus on the important priority of permanently codifying OAG's statutory authority to enforce the HRA. Thank you for setting this hearing on this important bill and for the opportunity to testify. I'm proud of the work OAG has done for district residents to fight discrimination. The provisions of this bill will allow OAG to continue its vigorous enforcement of the district's anti-discrimination laws and build on the civil rights legacy that the council has led on for decades. Alicia and I are more than happy to answer any questions that you may have. Thank you so much.
Thank you very much. Director Khan, welcome.
Good morning, Chairperson. Thank you. Councilmember Allen, very good to see you again as well, and Councilmember Pinto. Good morning, Chairperson White, Chairperson Allen, Councilmember Pinto, committee members, and staff. My name is Nin Kine, and I'm the Interim Director for the Office of Human Rights. Thank you for the opportunity to discuss Bill 24-0446, which seeks to make significant amendments to the DC Human Rights Act that will have consequential impacts for the public and the administrative services provided by OHR. In general, the executive is supportive of the intent of the amendment and agrees that there is an overall need to strengthen the HRA's enforcement mechanisms. However, this interest must be balanced with the need for effective processes and remedies for the individual claims OHR adjudicates each and every day. Certainly, the Office of the Attorney General has an important role to play in enforcing the Human Rights Act by having authority to bring large-scale cases like pattern or practice or disparate impact cases. The current bill, as written, however, goes far beyond this role and seeks to add provisions that would render the final decisions of both OHR and the courts unenforceable and meaningless. I will discuss this in greater detail, but first I'd like to offer some background on the work of OHR and our enforcement process as it relates to the HRA in order to illustrate the full impact that this bill could have on OHR and the people we serve. OHR's establishment can be traced back to 1973, and since that time, OHR has worked tirelessly to provide the public with an administrative relief for harms resulting from discrimination. As long as complaints fall within the agency's jurisdiction, OHR provides every filer with investigation, mediation, and a public hearing on claims in which we find probable cause. Moreover, filers at OHR do not need an attorney because once a complaint is docketed, OHR works to obtain relevant information necessary to resolve the claim. OHR's process is cost-free alternative to bringing a claim in court, which oftentimes is an expensive and intimidating process. OHR has 4 investigation teams, each headed by an experienced manager. This team works hard to conduct intakes and investigations for individuals who file complaints at our office. OHR also has an excellent alternative dispute resolution team, which offers free mediation and conciliation services. Finally, OHR is supported by a robust team of expert human rights lawyers within the Office of the General Counsel, which is divided into advising attorneys and litigation attorneys. The Commission on Human Rights, through our dedicated administrative law judges, conduct public hearings in cases where OHR has found probable cause. In these cases, as mandated by the HRA, OHR's attorneys appear on behalf of the district to pursue the public interest. If the hearing results in a finding against the respondent, the final decision may award damages to the complainant, including back pay, reinstatement, attorney's fees, and other compensatory damages. OHR will also pursue public interest remedies such as voluntary compliance in policy modifications, trainings, and postings of notices of rights. With all of the foregoing infrastructure in place, OHR has an incomparable understanding of the Human Rights Act and has a high legal expertise in enforcing the law. Indeed, in the majority of cases, OHR's final decisions are upheld by the DC Superior Court and the DC Court of Appeals. The HRA is one of the nation's most progressive and far-reaching civil rights provisions in the nation. The law currently protects individuals from discrimination based on 21 protected traits, but will soon be based on 23 protected traits starting October 1st, when homelessness and sealed eviction records are added. The HRA spans the areas of employment, housing, education, places of public accommodation, and access to government services. Over the last several decades, HRA has substantially expanded in coverage. Despite its recent expansion, however, the HRA does not provide OHR with the statutory authority to enforce its own subpoenas, much less litigate in court, which requires the agency to enforce its laws from a weakened position and denies victims the true depth of justice they may be entitled to under the HRA. In its early years, the federal EEOC was in a similar stance and was therefore dubbed the toothless tiger. In 1972, Congress amended Title VII, which endowed the EEOC with the ability to bring civil actions in court. EEOC, though, is not the only administrative body with this kind of robust enforcement authority. It also exists at the state and local level, and examples include California and Hawaii. Extending the HRA's enforcement authority to the Attorney General to prosecute large-scale disparate impact and disparate pattern or practice cases will partially give more teeth to the law, but that's only one part of the picture. Moreover, doing so should not result in rendering administrative or court decisions meaningless. With this backdrop, I will now turn to the specific provisions in the legislation that require Council's attention. The most significant piece of this legislation is the addition of new section to the HRA, which would provide OAG with unfettered powers that will render all past adjudications meaningless. This is because it will grant OAG the authority to bring any type of human rights cases to court at any time, as there is no statute of limitations and no prohibitions on retroactivity. Even more concerning is that there is also no prohibition on OAG bringing a civil action in a matter that has already been settled or a final decision that has been rendered on the merits, regardless of whether that settlement or decision occurred at OHR or in court. Rather, the proposed new section does the exact opposite and expressly provides as follows: that a private complainant's final adjudication or settlement shall not preclude the Attorney General from seeking any remedy on behalf of the district. This section essentially renders the settlement orders and final merits decisions of both OHR and courts largely pointless, as there will be no finality to the issues. Allowing OAG to relitigate cases that OHR or the courts have closed in mediation will remove any incentive for the parties to resolve the cases without full litigation. In the last 3 fiscal years at OHR, our ADR unit has resolved on average an average of 44% of the docketed charges. The national average for settlements in similar cases is 18%. The threat of eliminating this kind of success is a huge detriment to constituents who bring individual claims to OHR because they will lose out on an opportunity to be made whole, all without any clarity about whether or not the Attorney General would pursue their case. This could be especially burdensome on residents who do not have the time or the funds to continue to fight wealthy businesses that may be discriminating against them. In fact, it would motivate businesses not to settle at mediation, wait for the case to go to the OAG, and lengthen the time to resolution. Additionally, operationally for OHR, the lack of incentive to resolve cases at mediation would result in many, many more cases going to full investigation. And because OHR conducts a very thorough investigation, this could add to our backlog. Another issue is that the proposed concurrent authority for OAG runs counter to a current provision of the HRA, which prohibits a case from being filed at both OHR and the court. This is a long-standing legal principle designed to prevent the same claim from being adjudicated twice by 2 different bodies, possibly at 2 different times, and potentially resulting in 2 different outcomes. As previously noted, this is especially problematic given that the current legislation would allow OAG to bring a claim at any time. Aside from legal claims, this kind of concurrent authority without limit and clarification will cause confusion and impose an unreasonable burden on the parties. For example, for complainants, especially those without counsel, it will be unclear whether they should file their complaint with OHR or OAG. In the end, this confusion could result in a complainant's inability to bring their individual claim. This is because, unlike the Attorney General, individuals have a statute of limitation within which they must file their claim. For respondents, concurrent authority could impose an unreasonable burden because they could be required to go through 2 litigations for 1 claim and in 2 venues. Finally, because OHR and OAG could simultaneously but separately investigate the same claim, it is an inefficient use of government resources and time. Another section of the bill would allow OAG to conduct quote, investigation to determine whether to seek relief. This is problematic because calling OAG's vetting process an investigation is misleading and confusing for the public. Of course, OAG must be afforded the necessary tools to determine whether to pursue an action, as my colleague stated, pre-suit discovery, by having subpoena power and the ability to examine witnesses. But calling this process an investigation will lead to greater confusion, since OHR conducts an investigation that results in a finding, whereas OAG investigation would not result in any determination on the merits for the parties. This is mostly problematic because it has the potential to harm claimants, most of whom are not represented by counsel. For example, if OAG makes the determination not to pursue a case and meanwhile the statute of limitations expires, the claimant loses the ability to file with OHR or in court. Even if this fate were ultimately avoidable, a late filing, either with OHR or in court, the resultant delay would make it harder to obtain facts and information to resolve the matter. Finally, the legislation suggests that many of these concerns may be worked out by OAG and OHR by entering a memorandum of understanding to address the specifics of how this new legislation will be implemented. An MOU, however, is not a legal substitute for a carefully drafted and well thought out statute. These procedures must be carefully considered, reviewed, and codified to provide a fair, clear process to protect the rights of the people we serve. This bill also seeks to make technical amendments by updating and clarifying the definition sections in the HRA, including those related to parties in real estate transactions, such as the term real estate broker or salesman. It also updates the HRA's references to corporation counsel. Although there are some minor technical issues with these amendments, for which OHR is available to discuss, OHR supports these changes and has no substantive concerns at this time. However, in addition to technical changes, the bill also makes substantive changes in this area, which, if adopted, will extinguish the rights of individuals. And that's why I want to continue to highlight that concern for you today. For example, currently when OHR finds probable cause in cases involving real estate transactions, the complainant can elect to have their claims decided in a civil action by making a request to the OHR director. If a timely request is made, OHR refers the case to OAG, and OAG must file a civil action on behalf of the party in Superior Court. The current legislation seeks to repeal these provisions entirely, which means individuals will no longer have the opportunity to elect to move their claims to court as counsel intended. Another example involves enforceability of final orders. At present, if a respondent has failed to comply with the final order of the commission must seek OAG's assistance to enforce the order, and the law provides OAG shall then institute a civil proceeding. This legislation as written currently alters OAG's required role to a discretionary one by changing the term shall to may in DC Code 2-1403.15b. This completely erodes the strength of the administrative process, because if a respondent hasn't corrected the unlawful discriminatory practice or otherwise complied with the final commission of the final order of the commission, there is no guarantee that the order will be enforced when it is discretionary for OAG to enforce it. And OHR does not have the ability to enforce that orders on our own. This morning, I've outlined highlights of our areas of concerns, and OHR hopes to be able to fully address these concerns with both the council and OAG. I'd like to emphasize again that OHR believes there is both a need and a place for OAG's enforcement of the HRA by pursuing large-scale public interest cases like pattern and practice claims. On the other hand, we also believe there is both a need for OHR to expand its litigation authority, as well as to continue providing an effective, efficient, and robust administrative process to address and remedy individual claims of discrimination. This kind of balanced and clear delineation of roles is a model that's been tested and tried by our federal counterparts since 1972. This model also exists at the state and local level, and it is one that is more protective of the rights of individuals. Well, all that I have discussed today, I urge the committees to postpone further action on this legislation until OHR and OAG have had the opportunity to work together to define our complementary roles. This concludes my testimony. Thank you, Chairpersons White and Allen and members of the committees for allowing me to provide a lengthier than usual testimony today. I appreciate the opportunity to highlight the important portions of this legislation. As always, we look forward to working with committee staff as well as our colleagues at OHR. And I welcome any questions you may have at this time.
Thank you very much. We will jump in. We'll do 10-minute rounds. I have another hearing I chair at noon, and so I will probably move you along in your answers if they get a little long, because I do want to try to get to as much of the substance as possible. Let me start by going through some of the concerns that OHR raised specifically in the testimony, because these are the issues we really need to work through. The concern of OAG having unfettered powers that, in OHR's opinion, would render all past adjudications meaningless, because OAG would have authority to bring any type of HRA case to court at any time, no statute of limitations, no prohibition on retroactivity. Why is this degree of authority necessary for OAG, Chief Deputy?
Sure. So, the way the authority is structured is very similar to the authority that we have under other similar statutes, like the workers' rights laws, the consumer protection laws, and so forth. In general, what we've tried to do is streamline it to make sure that the Attorney General can act in the public interest where there is a determination that a bad actor has violated the law. And if I could just sort of take a step back on the concerns, right? Like, we've had this authority functionally now for the last 2.5 years or so, and these concerns that are being expressed have not really come to pass. And as over the course of the last couple of years, we haven't really encountered the problems that are being described. And instead, we have had a collaborative relationship where residents are able to go with their individual complaints to OHR and get those resolved, including through the robust and very successful ADR process. And also we're able to handle the more sort of structural underlying pattern or practice type issues through litigation. So it sort of worked out over the last couple of years. I think in the natural course, just as it's worked out in other areas. So I just wanted to highlight that as you know, the basis for why we think this is very workable, notwithstanding the concerns that have been raised.
I want to make sure the authorities are sufficient, but as we work through this issue, I do have concern making any decision based on sort of the past actions of OAG over the past 2 years, because this is, you know, whether it's an elected or appointed position, there will be other people, other leaders who will fill this seat, and I want to make sure we don't create something based on I have the highest regard for our Attorney General, I have the highest regard for looks to be our incoming Attorney General, but we can't predict past that. So as we work through this, I think we'll need to at least I will need to have a better understanding of why removing the statute of limitations and no restriction on retroactive suits is necessary in order to protect residents. I do want to make sure we have everything we need to protect residents, but I'll need to flesh that out with between OAG and OHR a bit. Similar question on the prohibition on OAG bringing action in a matter that has already been settled or finalized through OHR. Certainly if I were the defendant there, I feel like that wasn't fair. Maybe if I'm the plaintiff there, I like this provision. Help us understand how this sort of is fair in the administration of justice in protecting residents.
Sure. So the complainant as an individual who suffers discrimination has a claim that they are pursuing in this situation through OHR or perhaps through the courts, wherever they've chosen to pursue that. And that has reached a conclusion where they have been, remedied for whatever harm that they've suffered, let's say. But that doesn't obviate the fact that the district has a separate interest in that may be broader than the individual's interest that the district may want to vindicate. So here's an example, right? Like it's somebody who's a voucher holder who is trying to seek housing and an apartment tells them no voucher holders in our building. That's an act of discrimination that individual voucher holder may litigate, may not, right? Like they may choose to move on and just find another place to live. But let's say they do litigate it and they get relief through the OHR process that they find satisfactory. What that doesn't address is there may be any number of other folks out there that have gone to this housing provider that either we've heard about or that we haven't heard about, because not everybody is going to file all their claims. And the district has a broader interest in making sure that housing providers that have these types of policies or practices or procedures that affect a large number of tenants do get addressed, and that they sort of are penalized for the more broad harm that they've caused across the rental market instead of the harm suffered solely by the individual, which is being vindicated through the process. That being said, as a matter of reality, again, right, like we're not actually filing cases that have been resolved through the OHR process. Generally, if there's a resolution there, we're just as content to let it be, because as you all know, the volume of complaints and civil rights violations out there are so much broader than the resources that either of our agencies has to address them. And so, we try to use our resources as strategically as possible to bring claims that haven't been vindicated, like that blockbusting claim that I described earlier.
I appreciate that, and I appreciate the example, because you're hitting on something that I see and hear about a lot, and that frustrates me, which is discrimination against voucher holders. It's one of the forms of discrimination that we see and that we hear about. And the majority of folks who face that discrimination are not seeking remedies. For the city to have the power and authority to, when they do find out that this is happening, reach back and look at past cases where that has happened. I think that that is a good protection for residents, and would reduce the occurrence of that type of discrimination if people know that it is being enforced. I guess where I need to better understand is, if a voucher holder was discriminated against, they brought a case through OHR. It was, or let's say they litigated the case to the court. The court has closed out that case. And then OAG comes a year later and reopens it. That I have trouble wrapping my head around that. If you could help me understand why that level of authority is appropriate.
Yeah, so I don't think we would be reopening that, right? Like what we would be doing instead is to say, let's say we come back a year later, in a case that we would actually pursue in that situation, what we would have found is that this practice affected the market much more broadly than this individual who suffered harm. That instead, there may have been others, there may have been some advertisements, there may have been some much broader harm that was not vindicated through that decision. Again, as a matter of reality, I don't think we're going to be pursuing terribly many of those claims, and we haven't, but I think that there might be a situation where we do, and that would be the situation, is where there's some much more broad-based harm that we determined wasn't vindicated. And of course, right, like a defendant, I think, would be within their rights and fair enough to say that at the stage where either penalties are being assessed or there's being a determination as to, what sort of penalty they'll be imposed or restitution that they'll pay, is to say, no, we've already paid X, Y, and Z already in a previous action, and a court has discretion ultimately in terms of what remedy is issued. And so a court would be, and I think it would be entirely appropriate to consider the fact that, they have already made some subset of the harm that they've caused. They've addressed that, but there's some additional harm.
That's very helpful. That makes sense to me. That's the clarification I needed. That then prompts the next question, which is, how does this not disincentivize people from going through OHR's process?
So I don't think it disincentivizes going through OHR's process, because the individual needs to, there's an individual complaint in the OHR process where there's a person who has suffered harm and who is seeking to vindicate their rights. And so in some form or fashion, that has to be addressed. We don't represent the individual when we bring our cases. We represent the District of Columbia and the broader public interest. And so the defendant in that situation is incentivized to resolve the case that's before them. And again, I do want to go back to the broader point around our practice here, which is that we haven't really gone back in. And so I think bad actors know that when they resolve it against the person, that we're not reopening sort of those individual cases unless there's some broader harm that's at issue. If bad actors know that we can investigate and sue, they're more incentivized to resolve the issues and agree to correct their conduct in mediation, so that we have nothing, so that we have nothing more to look into and no broader harm to investigate or sue over. So we think in some ways this could actually add an additional layer of an incentive to, get their business practices in order quickly, so that OAG doesn't come looking at sort of more broadly what are they doing across the market other than with this individual.
Okay. Chairperson Allen, would you permit me 1 minute to see if Director Khan has sort of general thought? I'm going to come to you, Director, but you're
anticipating my very first question, which was going to go to the director to kind of follow that thread. But if you want to go there, go for it.
Let's let you go, Chairperson. I just didn't want to leave the director hanging. So
well, it's beautiful teamwork, right? So I appreciate that. And first off, thanks to everybody for your testimony. And I really appreciated Councilmember White's kind of thread of questioning there to OAG, because I think that was helpful context to understand, at least from your perspective, what that intent of that legislation and how it can be used. So I want to make sure, Director Kine, you've got a chance to talk about this. So obviously, again, the permanent bill would allow OAG to bring cases at any time, regardless of any statute of limitations, as I understand it. Trying to understand both how is that fair to defendants, but also what is the goal from a pattern of practice, hearing from the OAG. Could you talk a little bit more, Director, about how do you hear that response? And then in what ways do you either agree or have a counter position you think we should be considering there?
Thank you, Chairperson Allen and Chairperson White. I'll keep this brief because I know everyone's tight on time, and I appreciate you all putting up with my lengthier than usual testimony. So 3 points. One, regarding concerns not been a reality before. That's not exactly accurate. We've been burned before, and the public has been burned before. That is a case that involved, I want to say 2018 or 2019, that involved a restaurant which case we resolved at OHR, but OAG ended up resolving, and we didn't learn about that except for when we saw it in the media. And so that's the kind of cases where there's duplication of efforts for the same exact issue that occurred in one venue. Number 2, regarding public interest, I just want to highlight, I added this a bit in my testimony, I'm not sure it was caught, but that under the HRA as currently exists today, OHR is mandated to pursue public interest. So it's not that we don't have broader public interest, we do. And we do pursue those through our cases that go through the commission, where we seek voluntary compliance agreements which we monitor for at least 2 or 3 years to ensure that the respondents are engaging in corrections and policies and training and that sort of thing, as I mentioned in the testimony. The third piece about there being lack of an incentive to resolve cases at mediation with this unfettered sort of broader power. I think that my GC was itching to respond to that, so I'm going to pass that to her if she wouldn't mind.
Apologies on my mute button there. No, I just think that we're not talking about resolution. We're talking about actually in mediation, in conciliation, of getting a respondent to the table and actually agreeing to resolve the complaint. And I'm not sure how we have that when, despite my colleagues' pronouncement that they're not going back in there and wanting to change settlements. If you look at the language of the bill, the language specifically states that that is the power that they're allowed to do. So while I certainly, I appreciate the sentiment that you haven't done that yet, the current legislation allows you to do that. And I don't see how we could get respondents to the table to meaningfully settle cases when that language is still in the bill that would allow the Office of the Attorney General to come in and exercise a reopening, even these individual cases.
Okay, but how, trying to get to a resolution, how do I look at this from OHR is more focused on the individual complainant and getting a resolution to that individual complainant, and OAG is going to often look at pattern and practice beyond the individual scope.
So if I can take that up real quick, there is, in every single case that we see at OHR, there can be a public interest component. As a public government agency, every single time we look at a case, we look to see if there's a public interest issue that we ought to pursue, right? Like, again, changes in policies that impact the public, our residents and our filers. So there's that. And it's true that, as I stated in the testimony, as our colleague from OAG has said, OAG will and should pursue these larger cases. What I'm saying to Councilmember White's question about, why reopen the cases that OHR has had, and my colleague's response was to deal with broader issues that may not have been vindicated through our process. Sure, but let's make sure that the process is streamlined so that it's not happening twice in 2 different venues when it could be happening together or at the same time, or at least that the agencies are communicating, and that there's infrastructure for that kind of fair, clear, transparent process in the legislation to allow for that to happen. I don't think, we're not disputing at all that OAG has that role and they have the expertise to handle those larger cases and pursue much broader public interest than OHR can. But let's have a process and structure for it in the legislation, in the bill. Okay.
Mr. Swart, let me turn back to you. When we're talking about this issue of being able to look back and regardless of statute of limitations, Is that authority common with other OAG pattern or practice authority, that there's no statute of limitations? Consumer Protection Procedures Act, for example. Can you talk more about how you think this is either parallel or equivalent to other authority?
Yes, you're absolutely correct that it is similar to our Consumer Protection Authority or Workers' Rights Authority, and several of our other affirmative litigation authorities similarly do not have a statute of limitations because we want the Attorney General to be able to go look, to dig deeper, right? Like on an issue that comes before the office to say, well, what has this business or entity been doing historically, and how does that fit in to whatever investigation that we're going to pursue? And I think, even more broadly than that, Chairman Allen, is this is very similar to this, the way that this bill is structured and the how we're operating here is very similar to how we operate across issue areas, where there is an executive agency that deals with individual matters, for example, DOES and worker issues, or adult protective services and some elder issues. So we have this setup of executive agencies handling individual complainants and sort of working through a process to get them relief in a streamlined fashion, while also having the Attorney General focused more on the broader public interest and on the patterns and practices across issue areas. And so I think that this approach in the civil rights space is very consistent with that in other spaces as well.
Okay. I do think I am concerned about whether we call it a duplication of effort or frankly a lack of coordination at times. And I think it's been, there's been an example shared. Whether that's a formal notice requirement from OAG to OHR, or whether that is established within the MOU, I'm not exactly sure what the answer is, but I do think it's a fair thing that OHR needs to have some type of notification process that so that there is a greater awareness. And that's, take away the individuals who's leading which shop. That just feels like from a process standpoint, is something that needs to be there. I know my time's gonna run out here, so let me just ask another quick question so that we can kind of get this on the record. And I'll ask each of you for a 1-minute response, but no more than 1 minute so that we keep to our track here. So what do you think would be the impact of the Attorney General's office bringing a case against a party at the same time that the aggrieved person is in the middle of an OHR process against the same party? Would that party be incentivized to settle in one or both cases? Would one case have to continue or actually pause because of pending action of the same party? Each of you has 1 minute. So Mr. Swarup, I'll let you go first, and then Director Kine, I'll turn to you because I think that's a helpful perspective to get.
Sure. So first of all, right, like we hope that situation is unlikely, and it has not occurred in the last couple of years while we've had this authority. So just want to make that clear. But in that very unlikely situation that comes to pass, I think what we would want is a coordinated approach to make sure that we are resolving the matter globally. This happens all the time where we bring a suit against an entity and the federal government has a suit against them or another state, and we work collaboratively with others to figure out how we can resolve our, there's different interests that are being vindicated in the two fora, but just make sure that that we're doing it in a way that conserves as many resources, enforcement resources as possible.
Okay, thanks. And Director?
Thank you. So the key issue is that it's going to run counter to the provision I was telling you about, where you can't have one case existing two different forms at the same time. So that's legally not possible or viable. Number two is inefficiency, right? I'm going to have two different outcomes, two different resolution perhaps. And so again, as you said, Councilmember Allen, that we just need to have lines of communication open between the two agencies to ensure an efficient and fair process for all the parties involved in both OHR and OAG pursuing our different responsible areas.
Okay. Isn't it conceivable that, for example, DOES could be going after an employer at the same time an employee is working with OHR against that employer?
Sure, but it's under two separate laws. So DOES might be adjudicating a non-payment of wage issue. OHR might be adjudicating a discrimination based on non-payment of wage issue. So it's two different laws being implicated.
Okay. All right. That's helpful. I know that we're staying on track in time, so let me turn back to Chairman White. Thanks so much, and thanks again, everybody, for your thoughts and recommendations here.
Thank you, Chairperson Allen. So let me pick up there, Director Kine. Why does it matter if it's two separate laws? It's still two suits and two agencies about the same issue. So why is that distinction important?
One, because you could have two incongruent outcomes, right? I can tell you that because OHR is charged with the primary agency to enforce the Human Rights Act, that even courts look to our decisions for precedent. As you know, the district law is much more nuanced, much more progressive than federal counterparts. And most of the time, courts utilize federal case law to adjudicate or analyze the claims. And OHR has been seen as the expert in DC laws. And so when you go to another forum that doesn't have the same expertise and the outcome is different than what OHR would have interpreted, say in sexual harassment that's coming up, that's going to be two very different outcomes. The other issue is that if OHR has a case pending and if OAG is pursuing the same case in court, do we dismiss the case, again, because of this provision in the HRA that prevents the same claim from being in two different forums? Do we put it on hold? What do we do with it? And so those are the concerns. And I don't pretend to have all the answers today. I just think that we need to talk through these issues the way that the council members are asking together in order to figure out the answer.
Appreciate it. Speaking of two different forums, I forgot that my colleague, Councilmember Pinto, was multitasking. So let me pause my questions and turn to her for questions if you have some, Councilmember Pinto. Let me do this. I do think Councilmember Pinto has questions. And so Councilmember Pinto, when you jump on the screen, I will pause. In the interest of time, I'm going to squeeze in another question. Chief Deputy, if the permanent bill before us does not pass, what will be the consequences for district residents?
Sure. As I mentioned, we have several pieces of ongoing litigation, as well as a dozen or so investigations, some of which are, I think, going to mature into litigation in relatively short order here, and are dealing with some really important issues around various aspects of discrimination. And I think it would certainly be raised in litigation on all of those matters, whether or not we had the authority to either pursue the investigation or not, or continue the litigation. And so basically everything that's been in stream for the last couple of years would come to a halt, at least in regard to having to litigate that dispute. We still think we have arguments around our inherent authority and around the authority, around the temporary authority, around consumer protection authority. So we have legal strategies that we think are viable, but it is a risk, and it certainly, at a very minimum, is going to cause significant delay in all of those matters.
Director, what do you think will be the impact of OHR decisions not being final? How do you think that? How does that play out?
Again, that could have, what I'm going to call a tsunami scale effect on OHR's work and the way that we're perceived, right? If our decisions have no finality, it's not enforceable, you're going to get sued again, then why come to OHR? So it will render the whole process meaningless, and weaken our ability to really have teeth even more so than we have today. So essentially, we're going to go backwards instead of going forward.
Chief Deputy, what are your thoughts on that?
Look, I don't think that I don't know whether there has been over the last 2 years a significant decrease in the amount of people that are going to OHR, or a significant reduction in the resolution of OHR matters, or significant additional delays in those resolutions as a result of OAG having concurrent express authority. So I think, if there were some data behind that, I think we would be interested in that and happy to discuss that. But as a general proposition, individuals are still going to need a quick and efficient way to resolve their individual claims, and that's what they're pursuing before the Office of Human Rights in the main. And what we are pursuing is the public interest, the district's interest in eradicating discrimination more broadly, to eliminate sort of policies, patterns, and practices of discrimination. And so I think there's not the idea of that there are sort of the same case in both fora is not quite correct, because the complainant, the plaintiff before OHR, is the individual who suffered discrimination. The plaintiff in our matters is the District of Columbia and the public interest. So there is a different there's a different set of claims, a different set of plaintiffs, and a different set of interests that are being vindicated, even if from time to time there are overlapping facts, which, as I mentioned, since we've sort of formalized our civil rights section and formalized our processes, there hasn't been. So that's what I would spotlight in response to your question.
I'm going to stop there. Some of my questions are now not relevant because of recommended changes that OAG has made. Some are details that I think we're going to have to work out, like whether we call it an investigation or something else. I do think that we probably have some commonality around ultimate goals of fairness, maximum protection for district residents, and legislation that has the effect of reducing discrimination. So there may be other goals, but I think we sort of have the roadblocks to figure this out, and generally want to see the same things. So this has been really helpful for me in clarifying where we are, where we need to go. So let me turn to Chairperson Allen, and note that Councilmember Pinto is with us, but is having tech issues.
Great. Appreciate that, Councilmember White. Just being cognizant of time, I just have a couple of quick questions to clarify that, and then anything further, I know we can follow up with the representatives here. So just a couple of quick pieces. One, under the current bill, it would provide that remedies would go into the OAG's litigation support fund. Deputy Chief, can you just talk a little about why you see that is the space to go to? Is it because you're saying the aggrieved party is the district rather than the individual? Or how would the aggrieved or injured person receive any type of damages?
Sure. So this would work the same way as, again, our consumer protection and workers' rights type cases or tenants' rights cases, where if there's a penalty or attorney's fees or costs, those all come to the litigation support fund, which is, as a matter of operation of district law, how, where those monies go. But also, in appropriate cases, we will seek restitution on behalf of an individually identifiable group of victims if there's a pattern or practice that has a specific victimized group of people. And so, in a workers' rights case where, there's a wage theft, what we do is we make sure that the workers get the restitution, but also that there's a penalty to create a deterrent impact, and the penalty goes to the litigation support fund. So it would work the same way. If there's somebody who's discriminating against a tenant, the tenant would get, whatever recompense that they're entitled to or is appropriate, and then separately there would be a penalty that would go to the litigation support fund.
Okay, that's helpful context. Thank you. And then I guess kind of last question is, could you provide an update? And then Director, I'll ask you as well. What is the status of being able to work out some of these details or conflicts via an MOU? The legislation, I think, is the authority to create or helps create the authority for that MOU, but how are we doing in terms of working out some of these conflicts or details?
Yeah, I think we've had the director and I have had productive conversations dating back, I believe, 3 years now, for about 3.5 years. So I think we can make a lot of progress. I think, the issues that you were highlighting around ensuring that OHR has notice is really important and would be a key part of an MOU. I think we've distilled the issues, and I think we have made progress on getting closer together on those. And I think we certainly can do that. I just wanted to highlight, why we think the MOU is a better way to handle that than hammering out all of those details in the legislation itself. And really that's partially around, the flexibility that this type of collaboration necessarily needs. But also it's around efficiency in litigation, is that we don't want to create a whole bunch of defenses in the statute around, we don't want a defendant who is clearly engaged in wrongdoing to be able to escape liability because notice was given a day late or something like that, where we think we can work out those types of notice issues and make sure that notice is timely given without creating additional hurdles to resolving these matters.
Okay. And Director?
Sure. I'm a believer in compromising, so I'm happy to engage further with OAG, and I think we already have plans in the works to speak with each other next week. But regarding the MOU, I'll be truthful. I don't understand why we would put it in an MOU versus putting it in a statute. There might be some procedurals that are super nuanced that perhaps we could work out, but for the most part, when we're talking about how the orders will be enforced and how OHR shall be provided notice, I think that all needs to be put into a statute where it has enforcement and clarity, right? And as Councilmember White mentioned, when we have leadership that will change with time, MOUs are not helpful, but statutes will remain constant. So that's the reason for why we're urging for things to be included as much as possible in the statute rather than relegating it to an MOU, but certainly willing to talk it through.
Okay. So do we have a current existing signed MOU?
No.
We do not.
But you've been meeting for 3.5 years to create one?
I would not say it's been consistent over the 3.5 years because, there have been disruptions as a result of the pandemic, as well as changes in, our authority, as has evolved over those 3.5 years, and personnel changes as well. So there has been coordination throughout the 3.5 years on individual matters, I will say, but on the bigger picture issues, it's been more on and off the discussions. But I think, part of the reason we're urging the passage of the statute is once it's in law, I think all parties, there'll be an additional motivation for all parties to work efficiently to address all of these issues and move things forward.
Okay. I will just say, as just one person, if an MOU has been worked at for 3.5 years but not ever figured out, I am much more sympathetic to then saying, well, then I guess we got to add it in legislation, because 3.5 years is a fairly long time, even with a pandemic, to be able to get to some agreement. So I would consider myself more sympathetic to adding language in to be a bit more prescriptive if we haven't been able to get there over that amount of time.
If I can add one more thing to that is, I think part of why the MOU has not been hammered out is because of the desire on the part of, on one of the parties' part to make sure it's in statute, right? So I think that has been seen as the more desirable outcome from their perspective, which obviously we understand. And so I think that has been an impediment to making progress on the MOU.
Okay. Well, I appreciate everybody's testimony here. I think you've given us some really good context around some decisions to make, as well as some really areas that I think we've got to think through. So I'm grateful for that. I know that we know where you are, so we can track you down as well to kind of work through the remaining issues as we get ready. So Councilor White, thank you very much for your leadership here and co-chairing this hearing. I know you've got another long one all afternoon. So I think I'm done with my questions. Anything else I can certainly follow up on with the different representatives.
Thank you so much, Chairperson Allen. I apologize about the technical issues that Councilmember Pinto is having. I know she was eager to join. This was an incredibly helpful hearing for me. We stand ready to be helpful in working out the details. again, I think we agree on the big things, and so we should be able to figure it out from here. And it will require some work and some compromise, and we'll assist with that. I know the Committee on the Judiciary and Public Safety is used to working out complex issues as well. So we will rely on them. Let me mention as we close that anyone who is not able to testify, you can submit written testimony. It is welcomed and encouraged and will be made part of the official record. If you are interested in submitting testimony, do so by email to the Committee on Government Operations and Facilities at facilities@dccouncil.us. The record for this roundtable will close at the close of business on Thursday, October 6, 2022. With that, the business before this committee is concluded. The time is now 12:03 p.m. and this joint hearing is adjourned. Thanks, everybody.